I think we'll give it 1 more minute and then we start. Okay, so good afternoon, ladies and gentlemen. Thank you so much for giving us your time and attending another one of Nexus Information webinar series. The subject today is a subject which has been much talked about, and there is a lot of ambiguity about it. So we felt that this webinar could go some way in try to clarify it. And the subject is wills in the UAE. Now, the question that arises in the minds of so many people is whether you actually need a will in the UAE, because so many of us only plan to be here for a short period of time. So many don't necessarily own real estate here when we start when we start living in the UAE. However, as time goes by, all that changes, and we realize that it would be a good idea for us to have a will, but it's not. I mean, it's not something that is that easily and freely advertised and available. So this webinar is being hosted by Nexus Insurance Brokers LLC, which is the leading, award-winning, and the largest insurance broker specializing in life savings and investment programs across the GCC. We have also partnered up with CARM, who are a leading law firm based in the UAE and have a very, very active wills and estate planning and private client practice. Just want to cover a couple of housekeeping points before I hand over. All the video and audio will remain muted. So if you have any questions, please type them into the Q&A box. And also, if you'd like to discuss anything other than wills, please put it in the chat box and we will deal with it separately. So without further ado, I'm going to hand you over to Luna De Lang, who is one of the partners at CARM, who will introduce herself and CARM and will do the presentation. Thank you.
Reza, thank you very much. Good afternoon, everybody, and thank you for joining us on the Saturday afternoon, making the time to address something that is of particular importance for all of us here living in the UAE, or having some interest at least in the UAE, worthy of protection. I think this is a very necessary conversation, an important conversation to have in order to get one's affairs in order. And I hope that today's session will be informative and will result in a fruitful knowledge takeaway from what we can share with you today, and that you can essentially plan your estates accordingly. So thank you so very much for joining us. As adults, we spend our lives protecting our most valuable assets. Why do we need a will, or what is a will? A will is a legal document in which a person can dictate what their testamentary wishes are when they are no longer there to give effect thereto. So essentially, it's a part of estate planning where you execute a legal document that is enforceable to then carry out your wishes and to devolve your estate as per those wishes. We have dreams and aspirations, and we do everything we can to plan for them. We ensure that we have provided enough money for education, living expenses, a home for our loved ones, and ensuring that what we leave behind reaches the right persons. So essentially, in terms of estate planning, this is what it encapsulates. We plan for the future. We plan for the unknowns. One of the greatest unknowns is how long we will have time on this earth and how long we will have control over providing that much needed care and resources and essentially the security for our family and our loved ones. So as part of the estate planning, that is why we're speaking to you today about a will, to ensure that what you leave behind reaches the right person and persons. Estate planning, an important part of the financial planning process, which includes preparing a will. A will would be the first part and most essential part of estate planning. I'd like to introduce you also then to my colleague, Mr. Manav Joshi, who's going to take you through a few of the pros and cons of executing a will versus not executing a will in the UAE. Manav, please take it further and introduce yourself.
Thank you, Luna. Hi, everyone. I'm Manav, and I'm an associate at Quorum. I'll be taking you through the pros and cons of not having a will. So, whilst the UAE is an expatriate-friendly country and treats foreigners' assets sympathetically in the event of death, there are some complications which may arise when someone dies without having left a valid will. Firstly, it's important to note that any non-Muslim expat in the UAE setting up a will in your home country would not apply to your movable and immovable assets in the UAE, unless you have a registered, recognized will covering those assets within the UAE. So in the event of an individual passing away without a registered will, the UAE law of Sharia will apply to the division and distribution of your assets within the UAE. Under Sharia law, firstly, the spouses would be entitled to a lower share as compared to what may be favorable to you. The application of Sharia law would result in the wife of a deceased husband receiving only 1/8 of the estate left by him. Additionally, the husband of a deceased wife would only be entitled to 1/4 of the shares in his wife's estate. The reappropriation of the remainder of the assets will devolve as per Sharia law again, and would go to the extended family, such as your uncles, aunts, nephews, and nieces. It is also important to note that in the event of your passing without a valid will, which governs the guardianship of your minor children, custody may pass to someone you wouldn't want it passing to, or the local government may have to intervene. In the event of the death of the husband, the guardianship of the children would not automatically pass onto the wife, as she would not have legal entitlement to the same. The mother would be able to keep the custody of a male minor child only up until the age of 11, and the custody of a female child until she turns 13. The guardianship is automatically given to the next male, to the closest male relative of the father's side of the family, with no guardianship being automatically given to the wife of a deceased husband and mother of the child. Further, all bank accounts would be frozen for existing and all contingent liabilities, and all dependent visas would be cancelled, and the dependents would be needed to exit the UAE within a specified period. Regarding the benefits, registering a will in the UAE for your assets to be distributed as per your own instructions. There's no guarantee that your intended desires will be carried out. Having a will helps minimize any family fights or legal disputes about your estate that may arise. It also determines who, what, and when of your estate. A will will allow you to make an informed decision about who should take care of your minor children. Having a will allows you to appoint the person you want to raise your children, or better, make sure it is not someone you don't want raising your children. To avoid a lengthy probate process, all estates must, however, go through a probate process. Probate courts serve the purpose of administering your estate, and when you die without a will, known as dying intestate, the courts will decide how to divide your estate without your input, which can cause long and unnecessary delays. Having a will would mean that you wouldn't have to pay any estate taxes that would be levied on inheritances. Now, you can decide who will wind up the affairs of your estate within a will. Executors would be formally appointed and act as trustees to ensure all your affairs are in order, including paying off bills, canceling all credit cards, notifying bank and other business establishments of your passing, because executors will play the biggest role in the administration of your estate. The ability to also make gifts is a good reason to have a will, because it allows your legacy to live on and reflect your personal values and interests. Such gifts and donations are also not taxed within the UAE. Now, a will is a living document. So life changes such as births, deaths, divorce can create situations which are not covered in the original will. But as it's a living document, it should be changed regularly and cover your most up-to-date intentions. I would like to pass back to Luna to cover the eligibility and...
Thank you so much, Manav. We appreciate that. Thank you. So, ladies and gentlemen, just as a quick recap of what Manav has discussed with you now, the generalist understanding in which one must take away from today's knowledge sharing session is that if you do not have a valid will to exclude Sharia law under the UAE law, Sharia law will apply to your estate by automatic operation, and effect will be given to the distribution and redistribution of your assets under your estate as per Sharia law. Also, insofar as the custody and guardianship of minor children is concerned, this does jeopardize your planning insofar as children are concerned as to whom you would like for custody and guardianship to vest insofar as your children are concerned. One practical example hereof, and Manav had mentioned to you the ages of which a mother would have custody and guardianship of a child. However, one example would be is that if a father were to pass away, the next male in line, be it a father or an uncle or a nephew or a brother, would then have the legal entitlement to claim custody and guardianship of a child as opposed to a mother, and take away the physical custody as well as legal guardianship in order to make legal decisions regarding that child, as well as manage the monetary affairs of that child for the rest of their lives from the age of 11 onwards for a male child and the age of 13 onwards for a female child. Also, insofar as not having a will, it puts your family in a very precarious position insofar as the distribution of your estates are concerned, where they may be put in a position to try and fight for what they believe is, legally theirs and what they're entitled to versus that which the law says and what is applicable. It will be very, very difficult to contest the application of Sharia law in a court within the UAE if no valid will has been executed by a testator or testatrix in the UAE. So again, now we come back to the benefits of then executing a will. By executing a will, you essentially place somebody in charge of your estate. So you appoint an executor or an executrix of your choice, a person whom you trust and whom knows what your intentions are and whom you know will carry out those intentions. This can be a private individual, or this can be a firm who can do this for you. This can be an attorney who can do this for you. It could be your spouse. It could be any beneficiary under your will. It does not matter. For practicality purposes, it does make sense to appoint somebody within the UAE that does have access to the authorities here and whom has an understanding of the culture as well indeed dealing with the necessary authorities in the execution then of your will. That person essentially then steps into the position as a trustee of your estate, and they administer your estate as if they were you, but in the case that you're no longer there. And they are then in charge and are given, in a sense, a court order, a probate court order, which reads and says and dictates exactly what their rights and responsibilities are in respect of your late estate. So it puts you in control when you are no longer around. Very importantly, apart from children, it just helps to secure the safety and financial freedom of your family as well, insofar as the division of estate and money is concerned after your passing. So this is quite important. Please understand that Sharia law will differ very much and vastly from what law you consider to be that of your home country, in all likelihood, being a non-Muslim person, because this is the services that are available to non-Muslim persons in the UAE. So either then as residents or persons that have an interest within the UAE, provided that they execute it at the time that they are in the UAE legally so either under a residency visa or a visitor's visa at the time, then they're able to do so. All right, so just moving on now in terms of eligibility and criteria. In order to execute a non-Muslim will, this is given effect to under two very important pieces of law. Article 17 of the Law of Civil Transactions, this is the Civil Code, and then also the Personal Status Law. These two pieces of law are the most important pieces of law when it comes to the administration of estates for non-Muslims, because under these specific laws, you can exclude the application of Sharia law to your late estate, and you can make decisions regarding your personal status and the division of assets in accordance therewith. So essentially, this allows you to contract out of Sharia law and to apply the law of your home country or of a different region, the common law, etc., insofar as your late estate is concerned. It's very, very important. This gives us as expatriates, non-Muslim expatriates within the United Arab Emirates, it gives us the right to specifically contract out of Sharia law and then to make decisions accordingly and contract on a personal basis as to what our wishes are, provided there are no provisions in our wills that are contrary to public morals. So again, this applies to non-Muslim expatriates. It could be a resident of the UAE. They're enabled to draw up and register non-Muslim wills. The latest position is that if you have interest in the UAE, let's say as one example would be is if you have property in the UAE, but you're physically located outside of the UAE, you are permitted to execute a will within the UAE at the time that you are physically present within the borders of the UAE and legally so, again, on a visitor's visa. It provides then also for the governing of assets and arrangements concerning estate matters in the UAE. There are two types of wills that are allowed and that are recognized in the UAE. Simply speaking, a single will where one single person will draw up their own will to dictate what their testamentary wishes are. And then secondly, mirror wills where spouses execute a will at the same time, and these two wills, although they are two separate wills, they read symmetrical to one another. So essentially, to give you one example, if a spouse wanted to benefit, if a husband wants to benefit the wife would then benefit the husband accordingly in a mirror fashion in their respective wills. And I'll come back to you later insofar as costing is concerned, why we bring that up, because there is a cost benefit in the execution of a mirror will as opposed to just doing two single wills. And that is why we bring this up. So under this law, it makes provision for a single will as well as mirror wills. A will, as Manav had mentioned earlier, is a living document. It has no legal effect until the time of a testator or testatrix's passing. What this essentially means is that it will remain just as a legal document which has no effect and under which no instructions or wishes can be carried out until a person passes away. As such, and as being a living document, it can be amended at any given time. It can be revoked and replaced by a new will as per the requirements of the law of the UAE and whichever legal regime you elect to execute a will under. So again, as a living document, it is very important to keep the document up to date, meaning thereby if there are any new births, any new deaths, any divorces, marriages, etc., somebody that you would like to benefit under your will, somebody that you'd like to remove from your previous executed will that you no longer would like to benefit, then you make use of the amendment of such a will or the revocation and replacement of the will under this law. Lastly, also, any person who is non-Muslim and over the age of 21 is permitted to execute a will under the UAE federal law, because that is the age of majority here within the UAE. So on several occasions, I've had clients in the past who have said to me that they needn't specify what happens to their children because their children are of 18 or 17, whatever the case may be, and they are considered to be adults. In the UAE, they are not considered to be adults. Legally speaking, they will only be adults at the age of 21. So until the age of 21, you need to make provision, at least in your will, insofar as what happens to their guardianship and their custody arrangements. Insofar as them benefiting under your will, that will remain as per your wishes. All right. Estate assets for consideration. So when we advise our clients as to the execution of a will within the UAE, we tell them to take account of what assets they have and to conduct an exercise to really establish what is the value of their estate and what is it that they actually would like to protect, but not only to protect, but what do they have, what arrangements and wealth planning arrangements do they have in place to make sure that there is enough available to settle all their legal debts upon their death, and then also further to care for their family, to pay all estate duties, whatever they may be payable from their estates, and just to make sure that there is something left as a legacy for them, for the people who need it most. So assets for consideration would be any movable or non-movable properties. Any movable, the name speaks for itself. It's tangible assets that you can pick up and you can move around. Any non-movable assets, it's immovable property, it's fixed property, it's real estate. Any cash legacies, if you would like to leave a specific amount of cash to a person, be it then in a bank account, be it held in a safety deposit box, be it held wherever, in whatever form, you can leave an amount of cash to a specific person and make a specific bequest in their favor, and they would be the beneficiaries of such a bequest in receiving a cash legacy. Then all financial assets, we speak of bank accounts, and bearing in mind, then you think about all the bank accounts that you do have, savings accounts, current accounts, fixed deposits accounts, investment accounts, etc. So any accounts held by a testator or testatrix within the boundaries of the UAE. Now, very importantly, in terms hereof, Manav had mentioned earlier the pros and cons of executing a will within the UAE. Many people here within the UAE use joint banking accounts, or even if they don't have joint banking accounts officially, the account would exist in one of the spouse's names, but the other spouse would transact from that account and actually live off the means of that account. So the problem therein comes when a person passes away and that account is frozen. So the person is then left destitute who needs access thereto. In the case of joint bank accounts, which there are two or more joint owners of an account, if one of them were to pass away, the entire account is frozen. So one must bear that in mind. It is frozen for the duration of the execution of the will, which could take up to several months. So it is worthy to bear in mind these things and to plan ahead accordingly, to understand these processes and procedures and make sure that there is access to funds when it is needed most. So if it is held in a joint banking account or an account which a spouse transacts from, that they at least have their own banking account and have a separate facility to access funds from. And that's again where wealth management and estate planning would come into play, which Nexus would very kindly and very professionally help you with in respect of their expertise. Then also very popular, we speak of any crypto or digital assets. So in our practice as well, we also have a technology division within our practice. We are specialists in cryptocurrencies and digital money and all types of alternative finance means. So in respect thereof as well, you have to think of those things and things that may vest and only come to fruition in the next couple of years. But one needs to understand, where are these assets held? Who holds a digital key to a digital wallet, etc. How are they transacted? So these are all things that you can govern in terms of your will as to what must happen to these assets. Then also motorcycles, motor cars, arts and antiques, jewels, jewelry, home furniture and fixtures. So to give you another example in terms of home furniture and fixtures, if a husband were to pass away and they are the owner of a home and essentially also the fixtures and furniture, it could place their family in jeopardy if no will is erected and executed to benefit their family, to say that those assets should remain as is for the use and benefit and ownership of their family, or at least some family member that they can have access to, that those things are not frozen or confiscated, etc. after their passing. Then any debentures, leaseholds, bonds, security lockers, stocks, shares. So shares, again, it forms part of your estate planning, and then it borders on succession planning. Any shares that are held in a company, usually the company charter documents will dictate what is to happen to shares. However, it doesn't always dictate that, and even if it does dictate that, it often says that it will devolve upon the heirs of the shareholder. So if you do not specify in your will what is to happen to those shares, then it's up in the air and it will just devolve then into estate if you have no such legally recognized and properly executed will that is recognized under this UAE law. Any investments, if you have any investments and you have no specific named beneficiaries, then it will also devolve into your estate. You would like to ensure that those investments, and the same with inheritances, that it goes to the correct people. Mutual funds, any capital funds. Then most importantly, also something that is very popular and unique to this region is death in service or end of service benefits. So usually we always advise our clients, make sure that you tell your employer and that it is documented correctly what is to happen to your death in service or end of service benefits. Let it be paid to a specific person as it would be under an insurance policy, etc. There should be a specific beneficiary named. If not, it will form part of your estate. So you can choose accordingly how that should devolve. However, please make provision for same, either by means of a will or to make sure that it is included and instructed to your employer accordingly who should receive those payouts. In any reserves, insurance policy benefits, where no specific beneficiary is named on the insurance forms that we've touched on previously. Again, shareholding companies and any other assets not specified herein. So these are just to give you an idea of the types of assets for you just to do a stock taking exercise. Then the different stakeholders, just a few definitions. Manav and I have been speaking earlier, and we might have mentioned a term or two that are unclear to you. So just to give some clarity in this regard, We have spoken of a testator or a testatrix. A testator is the male person who makes a will or gives a legacy. A testatrix is the female form thereof. Then similarly, an executor or an executrix, most importantly, is their role. This is a specific person whom you nominate to look after your affairs and settle your estate upon your demise. They are appointed as trustees in terms of your will, and they act in this capacity. So the law provides that. They're actually trustees, and they are entrusted with your estate under a specific or with specific parameters of rights and responsibilities which they need to work there under. Then bequests of specific assets. This is where in your will, such as the example of the cash legacy, which I mentioned earlier, it is a specific item that you name in your will, which is an asset, which should transfer directly to a named beneficiary, the person who should receive that bequest. It is not the remainder of your will, it's not the residue that remains thereafter, but it is a specific asset that is removed from your estate and directly transferred to a third party, whomever the named beneficiary is, and it can include any asset. Then I'm coming now to the residue, a word I've just used a minute ago. This is what remains in your estate after the distribution of assets under your will, the payment of all lawful debts, your funeral expenses, and the expenses of winding up your estate. So this is what remains after all your estate has been wound up and all debts have been paid. That is the residue of your estate. Then a beneficiary legatee. This is a person or an entity who receives a profit, advantage, legacy, or benefit under a will. Essentially, it's a beneficiary, somebody or a legal entity that receives something under your will. We also speak of a substitute. This replaces any named person who predeceases you. Why we bring this up is because in your will, it is advised by us specifically to make provision for the substitution of specific beneficiaries, of specific executors, of whomever you name in your will, so that if they are not there and not alive at the time of your passing, or if they are unable to act in that capacity, or if they are unwilling to act in that capacity, then a substitute will follow. So there is a very great likelihood, if you were to name a beneficiary in your will, as one example would be perhaps a spouse, maybe they do not feel up to the task of executing your will. It could be a very sensitive matter, and in all likelihood it is. And they would need the time to process your death, etc. And out of respect for them, they then have the option to either elect somebody to act on their behalf, or you dictate in your will who that substitute will be. So you can essentially name one person to fulfill a specific role. You can name two people to jointly do or execute a specific role under your will. You can name as many people as you like. However, you can also name one, and then instead of this person, a second person as a substitute. Instead of that second person, then a third substitute, etc. So we can structure that for you accordingly. Then Manav had elaborated on this earlier and discussed this. This is the guardianship, and I'd like to discuss also the custody of minor children. So minors, again, any person under the age of 21 as per the UAE law. In respect of married couples, there is a general understanding that if one spouse should pass away or one parent should pass away, that the guardianship and custody would automatically transfer to the surviving spouse. That, however, is not recognized under UAE law, and that is why it is so important to specify this as per your will, where you can actually dictate what is to happen with your children. In respect of unmarried or separated couples, it may not be every testator's wish that the children's guardianship and custody vest in a surviving parent. So in their will, they are permitted to specify who they wish to grant guardianship and custody to. So what can happen in such a situation is that either that person will be nominated and appointed then to jointly act as a guardian and custodian of children, minor children, after your passing, together with the surviving parent, or they can be given guardianship and custodianship if the surviving parent is unfit. The court, a court of law with proper jurisdiction, will always have the final say insofar as what the best interests of children are concerned. So although you can dictate in your will what your wishes are, please understand it's not always what is executable in light of the law. The court will always decide what is best, and also only if this is brought to a court's attention and becomes a matter of contention in respect of your will. So custody would relate to the physical position of your children, where they would be based, and guardianship, again, as I mentioned earlier, would dictate what happens with your children, who are the decision makers in respect of their well-being, healthcare, education, finances, etc. So this is something very, very important, because also what you can dictate in your will is that the person who has guardianship of your minor children would then also receive as a trustee that child's benefit under your will, and will have to administer that benefit accordingly. So let's say you leave and there's a cash portion for a child to look after that child's needs for the rest of their life. This person will be responsible for that. Alternatively, you can make a specialist arrangement in some other form, and I will get to that a little bit later in my presentation, but you can have specific safeguards implemented in terms of your will to make sure that a child's assets are protected. Anything that they were to receive as an inheritance under your will up until an age of, or up until a specific age, let's say the age of 25, because at the age of 21, if I personally were to receive a lot of money, I'm not sure I would be as responsible as I am at this moment in time. So these are all decisions that you can make, and you make them in the best interest of your children. In terms of your will, very importantly, we personally and professionally make provision for the appointment of interim guardians and custodians of children. The reason for that being is that the permanent guardians and custodians of your children may not be physically present within the UAE, although you and your children are. So the interim guardians and custodians will be people who immediately take guardianship and custodianship of your children on a temporary basis until your children can be placed with their permanent guardians. Why this is very, very important is because, first of all, if you are a married couple and you wish for your children, even if you're separated, you wish for your children to be with their mother or with their father, then you specify this accordingly. However, if it is with a third party, let's say a very good friend that you have in the UAE, you can appoint them as interim guardians. And let's take the COVID-19 situation with which we're all faced now. There are several travel restrictions globally, and there may be some delay in having your children repatriated to live with their permanent guardian. So all of these things considered, these are the arrangements that you put into your will for the unknowns. Again, it's risk planning and risk mitigation, taking care of that risk and preparing for the what ifs of the world. All right. Again, we've just mentioned substitution, but I have discussed that previously. So in terms of the Nexus Wills package, this is the Wills package explained very briefly, and this is the simplified process. So Calm Legal Consultants has teamed up with Nexus. Nexus had actually initiated this process, and they had approached our offices, being specialists in these fields and having many years of experience insofar as estate planning is concerned, and together we had come up with the Wills package. And this Wills package is offered to you through Nexus. We are on the back end, we are the specialist consultants and advisors to Nexus and indirectly then to yourselves, and we avail ourselves accordingly through Nexus to you. So in terms of the Wills package, this is a package that was put together by Nexus to provide a simplified solution to yourself in order to execute a legally recognized and valid will within the UAE, and to address all of the necessary topics which I discussed with you a little bit earlier. So how this will package will work effectively is that you would undergo a consultation with your Nexus financial consultant or CARM legal consultants at your election. So we give you the option. Your Nexus financial consultant can consult with you. They will in any event do the initial consultation with you. And should you need a further consultation because there is a bit of planning or fancy footwork to be done, then we can give you specialist advice through CARM ourselves. However, it will come through the Nexus group, and we will accordingly assist you. So this is at your election, and it's an optional extra that we then consult with you on a one-to-one basis in accordance with and in order to plan your estate. Then from there, there's the completion of the required documentation. So there are onboarding documents that you would be required to sign and understand and properly mandate Nexus to undertake the service and provide the service to you. And therein contained are also the provisions then to say that this is outsourced to a third-party specialist who would undertake the drafting and drawing of your will. Then thirdly, we have for you a completed questionnaire plus supporting documents which are sent to and received by CARM from Nexus. So us as CARM legal consultants, we have tried to simplify the process by drawing up a wills questionnaire. This is a questionnaire which is a very basic questionnaire where we ask you what your wishes are. We ask you for personal details. We ask you who your elected and nominated persons are to fulfill several roles in terms of your will. We ask you what your wishes are upon dying. Would you like to be buried? Would you like to be cremated? Would you like to have a funeral? Whatever the case may be, you can dictate that in accordance with your will. We've also made provision therein because I mentioned earlier we are a technology specialist law firm as well. We were part of the team who had effected the Hayat app, the application in the UAE, which uses the Smart Pass and the UAE Pass technology, where a person can register through their Emirates ID as well to become an organ donor. So all of these things you can specify in your will, and we've made provision there for such in this questionnaire, where you can simply do a tick box answer for us and you give us the necessary details. And from there, our team will be able to devise a draft will in accordance with what we understand your wishes are. And that brings us to our first our next step, where a first draft of your will be prepared in English. And it's drawn up in accordance with the wills questionnaire, and it is then returned to the client for review. So a client will receive the first draft of their will, and we'll ask you, please have a look at that will. Please see that you read and you understand the contents thereof. It will be very simply worded for a very good reason, because we don't want there to be any cause of unnecessary ambiguity in the interpretation of your will. So it reads very simply, however, it reads also as a proper legal document. What we then send to you and we ask you, is this correct? Is this in accordance with your wishes? Are there any changes you wish to effect, or are there any supplements you wish to make thereto? You advise us accordingly. When we receive those instructions from you, we will do the necessary from our side between myself, Manav, and our legal team back at the office. Thereafter, once we've received confirmation that we have the finalized draft will in our possession and that you are happy with such a will, then we proceed to mandate a legal translator, a certified legal translator. This is a translator who has been certified by the Ministry of Justice as a legal translator. That legal translator will draw up your will, reading as a bilingual will, both in English and in Arabic, because the Arabic text is what is important for the Abu Dhabi Judicial Service, which I'm going to get to now. So it will be drawn up as a bilingual will. Why we do that is because we will never only draw it up in Arabic and expect you to sign a document as such. So you will have the English version alongside the Arabic version at all times. The certified legal translator is actually going to adhere their stamp of certification to that document to say that they attest to the fact that they have properly translated the document from English to Arabic. They then return it to our offices. We return it to Nexus, who returns it to the client for signing. We will then provide you with instructions insofar as signing is concerned. Right. One very important thing, the bilingual will must be registered at the Abu Dhabi Judicial Department. Otherwise, it will merely be considered to be your written wishes, all right? It will not stand as a legal will. So please remember, if you do not follow the processes of the authority for the registration and execution of the will, it will always just be a document where you've written your wishes and will not have the effect of a will and will not be accepted for execution as a will in any part of the UAE. All right, proceeding on. I mentioned to you earlier the Abu Dhabi Judicial Department. So as part of this Nexus Wills package, we have elected the appropriate authority which can provide you with the most cost-effective and speedy solution in order to execute a UAE validly recognized will, and that is through the Abu Dhabi Judicial Department. The Abu Dhabi Judicial Department has a specific and specified non-Muslim wills probate service, all right, and a non-Muslim wills probate registry. What this means, and Manav had mentioned earlier about a probate process. A probate will, the word probate comes from the Latin word probare, which means proven. What will happen is, once the will is submitted to the Abu Dhabi Judicial Department, they will vet the will. They will check the will. They will check for its validity. They will check the content, that there is nothing that's contrary to public morals. They check the outlay thereof, whether it conforms to the law and all the requirements under the law. And once the will has been vetted and confirmed to be correct by the Abu Dhabi Judicial Department, they then will notify us, or they will notify you, depending on who will do the submission of the will. And once they've done that, they will issue to you as the testator or the testatrix a serial number which will be attached to your will. Under that serial number, you are required to schedule a meeting with the Abu Dhabi Judicial Department at your convenience. They will then conduct via, as we are doing now, a virtual meeting. However, they use the Cisco WebEx virtual conferencing system. They will have a call just as we are having now, where the registrar of the non-Muslim wills probate registry service of Abu Dhabi Judicial Department will be seated. They will ask you to have your will in front of you. They will ask you whether you've read your will, whether you understand your will, and whether you are executing this will free of your own free volition, and that you're not under any duress or force to execute this will, that the will isn't done by means of, so in the past there has been fraud in respect of wills where people have contracted and said that if you do this for me, I will execute a will in your favor, so it's done by contract. So they just make sure that there is legal validity and substance to this will. They also then confirm your identity. So they'll ask you to have a copy of your Emirates ID on hand. They ask you to have a copy of your passport on hand, and together with your passport, your residency visa. They check that that is done. So as part of the registration process, they ask you to be dressed formally. This meeting takes about 20 minutes. And once that is done, your will is considered registered. It will be entered into the wills probate registry of the Abu Dhabi Judicial Service. That will mean once you are no longer here, that would be the standing will that will be accepted under the UAE law as being your last will and testament. And your family will not have to go through the court process of proving that that is in fact a validly executed will. So Also, just coming back to my screen here, where we mentioned here the UAE pass requirement for account creation. So myself, I have a UAE pass and a Smart Pass account with the Abu Dhabi Judicial Department because I have registered myself as a legal practitioner. I am a declarator. I can take instructions from clients and I can submit wills on their behalf under my name for vetting by the registry authority. Alternatively, if you undertake to do this yourself and not for CARM to assist you herein, you will be required to please go through and register under the UAE Pass or Smart Pass and do the account creation, and simply then follow the portal instructions, submit your will, obtain the serial number, arrange the appointment, etc. So you can do this yourself. It's just a more tedious process. And for guarantee purposes, I do recommend that you obtain some assistance herein. We'll come back to this as part of the wills package again, but I do vehemently advocate making use of assistance, because for a very small amount, which is 150 dirhams, we at least undertake as attorneys to ensure that there is due diligence insofar as the registration of your will is concerned, and that you do receive the documents back from Abu Dhabi Judicial Department, which is something very, very, very important. All right. Then, all right, so we've discussed that. Then here, the optional assisted services. Under the Abu Dhabi Judicial Department services, there is a notarization process that does take place. The notarization of a will, notably, however, the role of a notary is only to confirm your identity and to confirm what document is being executed, but they do not have regard to the contents of the document or any further role that they do play. So it is risky only to have a document notarized. That's why we say it needs to be notarized and registered. However, as part of the Abu Dhabi Judicial Service, they do notarize the will for purposes of the UAE. If you should require the will to be recognized elsewhere, or at least want to inform your home country of this will, then you will have to have it notarized by a notary public and attested up to the Ministry of and up to the ministry, and then also lodged at the relevant consulate or embassy of your home country or any country of which you are a passport holder. So these are all the assisted services that we can provide to you as optional extras under CARM. We do this on a daily basis. We have drivers and runners that help us with this. We have paralegal secretaries that deal with various logistical arrangements. So please, I invite you, if you would like assistance, please tell us and we will most certainly be happy to help you. One of the important things here is the one-on-one specialist consultation services of CARM. Like I said earlier, we do provide to you as part of the wills package a basic questionnaire from which we can derive for you a basic will. If you have anything a little bit more complicated, or you yourself need to satisfy your inquiries and have specific queries relating to the execution of a will and need more specialist services, and you need specifically legal advice, please come to us. So the optional extra that we have provided is that we have reduced our fees to 850 dirhams per hour, however made up in 15-minute increments. So prorated, then we will charge that as an extra fee. So you can take up 15 minutes of our time, 30 minutes of our time, 45 minutes, an hour, however long you need, however levied at 850 dirhams an hour, which is a reduced and vastly discounted fee should you require our assistance. And we're happy then to have a one-on-one consultation with yourselves in discussion of your estate and plan for you accordingly. The additional costs of the optional assisted services, so CARM charges, apart from the generalist charges of the drawing of your will, and then also the external charges, third-party charges of the translator, we can provide to you these assisted services at 150 dirhams each, and then together with that, our fees for consultation. All right. Reza, would you like to perhaps address anybody on the cost today, or will this be discussed separately?
What I would suggest is if the clients would kindly please reach out
Yes.
to their consultants, and they would be provided with all the details. I would much rather spend the time and address some of the questions which we're receiving quite a few.
Fantastic. Thank you so much, Reza. I advise the same. Please, contact your relevant consultant, have a one-on-one discussion with them. They can take you through this. So it's a package that's been designed. It's simplified. However, it provides you, it's solution orientated. So we have no doubt you will be satisfied having just, consulted with your consultant and having a look at what we can provide to you. What I would like to bring up as well, and I do apologize, I see the overlap in the text here, which was not there when we had created this. And please, this is not to confuse anybody. What we mean to convey to the audience here is that there are two other regimes, not only the Abu Dhabi Judicial Department, but there is RAK ICC, the International Corporate Center of Ras Al Khaimah, and then also the Dubai International Financial Center courts. They also provide will services. And us as CARM, we are qualified and we can undertake instructions to assist you with the execution of wills under RAK ICC or DIFC or ADJD, whichever one you elect to choose. And please, I request that you speak with your consultant herein, because these are more specialist services, and but we will be happy to assist you. We don't only do the ADJD wills, but we are specifically under the wills package. We're offering the ADJD service. And then additionally, if you should require, we are happy to take you through the RAK ICC or DIFC court service. And then also, if you're confused and would like more information about the difference between these three regimes, please, I invite you to consult with us in this regard and let us take you through the various options and the cost differences, the benefits versus the cons, etc. Then lastly, also not to confuse you, but relevant persons or specific persons, a will would be the first step insofar as their estate planning is concerned. However, if they should need a more sophisticated solution, CARM can also assist you in the setup of a trust or a foundation, and we do so within the recognized free zones of the UAE, or we do so offshore in Panama, the Seychelles, the British Virgin Isles, etc. So please let us know how we can assist you. All right, let's please move on to the Q&A session. Mr. Raja, I believe that you are going to be so kind as to take us through the questions of the attendees.
Thank you. Thank you so much, Leona. I think as well as Manav, I think they've covered the basic tenets of the entire thing. Yes, there are a number of questions that have been raised. I would go to the first one, which is, there have been many people who are asking, would the home country assets also will be eligible to be included in a will drafted in UAE? Would you like to take that up first, please?
Yes, please, Mr. Roger. Thank you, everybody. That is a very, very good question. Under the Abu Dhabi Judicial Department, presently, they only govern your assets within the boundaries of the UAE. Extending further thereto, the DIFC regime and the RAK ICC regime, they cover your worldwide assets. What I have to say as a precautionary measure is that this is a very recent development to say that RAK ICC and DIFC can govern your worldwide assets, and it has not yet been tested in the courts. That being said, it means that even if you were to execute a worldwide will within the DIFC or RAK ICC to govern your worldwide assets, it may not mean that another country would accept that will as being valid and applicable under their specific law. So my professional advice to you, please execute a will in whichever country you hold assets as per the laws of that country. That is the safest option, please. It's the most prudent thing you can do and the most responsible way to address your estate planning.
Thank you, Luna. I think that settles it. I'm sure every individual case might merit a different solution, and if anything that needs to be specifically raked up, please ask your consultant, and they'll be able to clarify that for you. Secondly, Mrs. Bhatia had asked if the assets like bank accounts and immovable properties should be specifically mentioned in the will. Will it help at the time of probate?
Yes, thank you. That's a very good question as well. In my professional opinion, ma'am, I actually always advise my clients to keep it broad, because if you're going to specify my Emirates MBD Gold checking account with this account number, let's say as one example, something would happen, or you would change a type of account, or they would sell to you an Emirates Sky Rewards account, that account number may change, something may change. And what it would essentially then mean is that that specific asset would no longer be in existence. So there would be another account, but it wouldn't be that specific account. So if you mean as a testator or a testatrix for a specific asset to go to somebody, yes, by all means you can do so. However, as a safety net precaution, we always say keep it as broad as possible. If you have fixed properties, say then all immovable property under my name at the time of my passing. Because if you name a specific asset and that asset doesn't technically exist in your estate at the time of your passing, it's disregarded. It's not even taken into account. So nobody will have the right then to come forward and claim another fixed property or another bank account asset of yours.
Right. So better to keep it generic, right?
Yeah, if that is your intention. So again, we always work with the intention of the testator, but my general advice would be that if you bind yourself and be too specific, there is always a risk that something could change. We don't know.
Great. The question is, what are the things to be kept in mind while in the process of probating a will?
So things to be kept in mind is obviously to ensure that you have addressed the necessary in respect of your will to cover that which you intend to state as per your last testamentary wishes. Because once it is probated, that is then accepted and entered into a registry as your last will and testament. Thereafter, if you do not again execute a will to replace and revoke the previous will, then that will always be your last will and testament. So it must be considered to be a personal responsibility that you take upon yourself to keep a will updated at all times, either through amendment or revocation and replacement through a new will. So that's very, very important to bear in mind. Insofar as the probate process itself, it's just a formality. It's just a formality, and it's just a administrative service that needs to take place. So it's more to do with the preparation beforehand and then the subsequent actions that you take afterwards.
Great. Okay. The other thing is, if you choose an individual to execute, can they be the beneficiary? And do they need to be a lawyer, or do they need any other qualification?
Thank you, Mr. Raju. No, an executor can be any person as long as they are over the age of 21, because they have to be a major under the age of majority as per UAE law. They have to be sound of mind, and there must be nothing that legally bars them from being an executor under the law. So technically they, to give you one example, a person that has conducted fraudulent activities and is on maybe a politically exposed persons list, etc., will not be your ideal candidate and may not be accepted by the court to handle your monetary affairs in respect of your estate. So choose this person wisely. It need not be an attorney at all. It could be an auditor. It could be a man on the street. It could be your gardener if you so wish, as long as it's a person of your choosing and a person whom you trust. They will essentially be given a job to do, and they will be monitored by the court that they do that job appropriately. So it need only be a person that is able to act as your executor, again, being of age, etc., and that you trust and can undertake a task of being an executor. I'll mention just once more is that for logistical purposes, it may be best to do somebody that either has access to the UAE or is based within the UAE. One example that I've had before in the past is where persons have nominated their parents who were resident in India. They were elderly persons, and they had great difficulty in executing their estates within the UAE. They, I'm so sorry for the noise. Please excuse me just 1 second. They had great trouble in doing so, and you know, it was just logistically very, very impractical for them.
Thank you, Luna. There is, I think, the question comes from, you know, in many of the subcontinent movies we observe, whenever there is a will, it's always a lawyer who walks in to the family and, you know, try to distribute. So probably that's where it's coming from. It need not.
Absolutely. I think, you know, and it is more of a common law accepted approach as well. From a practical perspective, a lawyer will always be a third-party impartial person. So they will undertake to do the necessary on your behalf. They know how to go about it, and they will take away the strain and difficulty of your family having to do so. So there is some benefit therein, but there is no need absolutely to do so.
Great. There is a technical question here. It says you mentioned the law of 2005, yeah? Whereas I believe there is one of 15 of 2017 concerning inheritance, wills and probate for non-Muslims. Can you clarify that?
Yes, of course. Mr. Raju, yes, absolutely. So 2015 is just when the law was effective, but always, I'm so sorry, we forgot to mention here, but it's always and the amendments there too. So it will always be the amendments that follow. And also hereinafter, if there are any federal laws that are affected, that will also then automatically apply to any wills previously executed. So we will always have to follow the law as it stands at the time of executing a will. So if there are any changes in this law, let's say, for example, they limit an amount of money that somebody can give to somebody, then that would be the practical application at the time of interpretation of that will when the time comes. So yes, absolutely. So here, just as we've mentioned the law here, this was just when the laws were enacted, but it always includes here and any amendments thereto or thereafter.
Though we covered the aspect of the home country assets, many of the clients in UAE have also got assets in different countries. It could be real estate, it could be offshore accounts, and somebody even mentioned Zurich funds.
Yes.
I think one thing that I can clarify is Zurich funds, if there is a beneficiary, they can be settled immediately without going through a probate. But with regard to the others like real estate and offshore accounts, what would you advise?
Mr. Raju, thank you. So again, just coming back to a practical perspective, the DIFC and RAC ICC now provides that you can execute a will for worldwide assets. However, we advise from a practical perspective, and having seen this before, is that please execute a will in whichever country you hold assets or have an interest. If you have children and you're separated from your ex-spouse and the children live in that other country, also execute a will in that country to make sure that there are guardianship and custodian provisions applied to those children where they are located. Same with assets, and correctly, as you've mentioned now, thank you very much, insofar as funds are concerned, there must be specifically named beneficiaries. It's always better that way. If there is a specific named beneficiary in terms of any investment or any fund, any accounts held, etc., what essentially happens from a practical perspective is that those funds, etc., are paid directly to a beneficiary. They do not even form part of your estate. So they do not get paid into your estate and then from there get transferred. The Swiss bank or in Zurich, they will directly pay the beneficiary once they receive your documents and the go ahead with the court order to say that they may do so. So it's very advisable, and we advocate this strongly. Please make provision for this and make sure that this is incorporated by necessity as part of your estate planning.
Great, great. Thank you very much. These are, I think, we still have a large number, and I think the replies are quite brisk and very nice.
Okay.
There's one more who says, if you return to India, can we still amend or revoke without a residence visa? Probably, I presume that they may still have some assets here, like bank accounts still open, or even they may have some property, etc. Then what happens if they cancel the residence visa and go back to India?
Thank you, Mr. Raju. That's a very valid question. So again, a person, you are not required to be a resident of the UAE to execute a will here. However, they require you to be physically present at the time. So if you had executed a will here in the UAE whilst you were a resident, or at least on a visitor's visa, but you have interests in the country like property, etc., then that will still be considered to be a valid will. So if you are in India at that time and you pass away, then there will still be your valid will in a probate wills registry in the UAE, and your estate within the UAE will be administered as such. I previously had also dealt with a matter where it was a gentleman, and he held a very high position in Siemens Ericsson, and he had 3 estates at the time. And what just happened was that each region had drawn up his estate only within that given territory. So he had one in Sweden, one in South Africa, one in Australia, and that's the best way to go about that. So even if you return to India, it doesn't matter at all. Let's say you did execute a will here, but the accounts that you held here are depleted, there's nothing in them, you don't owe any funds, it's essentially a nil. And also the property which you used to hold here is no longer in existence. Then your estate will still be carried out, but those assets will be considered null and void, and your estate will simply then be drawn up as a nil estate, and it will be closed as such. So nothing will happen there and after. But again, we plan ahead, we plan for now, and we plan for what may be in future.
All right, thank you. Here is a question again. You mentioned ADJD. Why not Dubai courts?
Thank you, Mr. Raju. Also, a fantastic question. Thank you so very much. So under the Dubai courts, or under any of the courts of the Emirates within the UAE, you are permitted to execute a will. However, and it is also in accordance with the 2 pieces of legislation which I've mentioned earlier. However, those wills are merely notarized. So I explained earlier what the function of a notary public is, only to ensure what is the document that you're executing, and they confirm your identity that it is in fact you doing so. And then they attach their notarization stamp, and the document is notarized, but it is not considered a probate will. So if you were to pass away thereafter, then somebody has to bring a court application to convert that as your will to a probate will. And that could take up to a year to do, and it will be an out-of-pocket expense for whomever brings that application, or essentially your family. So your family will be subjected to court proceedings and legal costs in order to prove that will. So that will is not proven if it only goes through the court system, like the Dubai courts, etc. So if it does not get entered into one of the 3 existing probate wills registry services in the UAE, then it is only considered to be a will, but it is not a probated will. It will still have to go through the probate process thereafter, which is costly, time consuming, and could also be a tedious exercise for a family in mourning.
Thank you. Thank you. Who should be witnesses to the will? Can they be executors and substitute executors, or can it be anybody?
So, Mr. Raju, under the Abu Dhabi Judicial Department system, their regime, they do not require any witnesses. The registrar himself who conducts the interview with you, he himself or herself will be a witness to the will. There is no need for any independent witnesses. Under the RAC, ICC and DIFC laws, they do require you to have witnesses, and they've got specified requirements as to who can be witnesses. So once again, it should be a person that's over the age of 21, a person who is of sound mind, and who actually can act as a witness underneath the will. A witness can be a beneficiary of the will, and a witness can also be a named or nominated executor under the will, because there would be two witnesses in any event.
I see. Thank you. Thank you, Luna. Here is a question. It's a little longer. It says, we have a will which was prepared 5 years ago in Dubai. Is there any aspect of the will that needs to be validated subsequently? Also, is there any online site where we can verify the details of the will? Or will was notarized but not registered with the consulate? Does it mean it's not valid in UAE?
Mr. Thank you. That is a great question. The will is absolutely valid. However, it would have only been a notarized will. So again, it is a will, but it is not entered into any probate wills registry. So as I discussed previously, it will then have to undergo, once the person passes away, it will have to be brought under application through the courts, under the Dubai courts in this instance, to have that will probated, which is costly and is a lengthy process as well. So what my recommendation would be is to rather to revoke the previously executed will and do a new will under the Abu Dhabi Judicial Department, which is a federal system, whereas this is just a Dubai court's notarized will previously. There is no way for you to check this online insofar as I am aware of any registry of that will. I apologize, I'm not sure how that can be checked. I'm quite sure if you do still have the details of the notary, they should have some or other registry. However, that registry would just be a bookkeeping exercise. It would have no validity insofar as that will is concerned. Like I said, a notary will only verify the document executed and the identity of a person. There is no guarantee that that will which you had executed is legally sufficient and compliant in respect of the law, because it hasn't been vetted by a registry service. Thanks, Mr. Raju.
Thank you, Luna. I think the last question about somebody who is not a resident, I think that opens up a huge possibility, because there are lots of properties here which are owned by non-residents.
Right.
You know, they come here and buy. I think it's all advisable that they should visit and register a will, right? Here is another, I don't know, it's an anonymous attendee who says, how long is the whole process approximately? I'm not a resident of UAE and I need to do a will as I have properties. Can I still do it?
Absolutely. So, yeah. Mr. Raju, thank you. And yes, the only requirement presently, and this may change, please. So from a practical perspective, if there is enough pressure and enough inquiries at ADJD or any of the other regimes, they may create leniency insofar as the physical presence is concerned. But the present situation, and with COVID, is that they do allow for the execution of a will as long as you're legally present within the UAE. So here, visiting on a visitor's pass, then it can be done. If you consult with your consultant and plan a time that you do come to the UAE, then we can fit that in, make sure that we do have your will beforehand, that it is drawn up, that it is translated, we can have it absolutely ready for you. Then we can submit it to the Abu Dhabi Judicial Department, and we can make sure to schedule that appointment for you within that time frame that you are here. So as long as we always understand the urgency of time, we can arrange that for you. Generally, in the execution of a will, it takes between 2 to 3 weeks from point A to point Z in you receiving your documents back from Abu Dhabi Judicial Department. all only depends on third parties. Third parties meaning the translators, sometimes they take a little bit longer. And secondly, the Abu Dhabi Judicial Department themselves, as and when they can accommodate you. And then also, sorry, another factor is the number of revisions that we have to do, because when we receive an instruction, we're not always immediately available. And also myself and Manaf being attorneys, we will always have oversight as to what needs to be effected and done. And I would always like to have sight of a will before it is sent out. So we make sure that is done in-house, both of us. We both have sight of that and make sure that it is properly done. So that in itself in-house takes us 2 or 3 days per revision, depending on our personal schedules at the office.
Right, thank you. Is it advisable to have a power of attorney as well, even if somebody doesn't have any business interest or any immovable property?
So a power of attorney, Mr. Raja, is a standalone document and should not be misguided as being a document to replace a will. A power of attorney would only be sufficient for a specific purpose. So one example would be is like, why would you execute a power of attorney? You'd execute it for a specific purpose to empower somebody else to act in your place and stead for a specific reason. And their reasons are governed within the parameters of that document for them to act on your behalf. But a power of attorney and its validity comes to an end at the time of your passing. So at that stage, then it is nullified thereafter, and that's when a will kicks in. So if you need somebody to do something for you and administer your affairs on your behalf, if you cannot do so, then yes, by all means, have a power of attorney in place. Power of attorneys are particularly important in the case, I believe, of spouses and elderly parents as well, for children to help them to administer their affairs accordingly. I'm presently now at the moment, I'm helping a family who had brought their parents from India, elderly parents, very sickly parents. They'd undergone extensive medical treatment here in the UAE, which has cost a lot of money, and we needed a valid power of attorney to be executed for use in India so that funds can be transferred from India to the UAE and then accessed in the UAE by the children as well. So it's a little bit of a more complicated affair, but that's why I say speak to us, tell us what your needs are, and we can accommodate you accordingly. We have a global affiliate program because we ourselves, we are not only located in the UAE, well, in fact, we're located in 3 of the 7 Emirates in the UAE, but we are also located on the island of Malta. We have affiliate offices in the UK, and we have various other affiliate partners offices in the Far East, various spaces, also Australia, South Africa, and the Americas as well. So wherever needed, we can assist.
Great. Okay. Again, another technical question, end of service benefits. Yeah, because some of the companies do take a nomination form from the employee to nominate the person eligible to receive the end of service benefits.
Yes.
Will this work legally, or the employee should still have a registered will?
You must still have a registered will, please. We always specify in our wills, and Manaf can attest to this fact as well, is that we keep it broad again. We have it as a catch-all in a safety net. And we say there that effect should be given in terms of this will only if there are no specific named beneficiaries under policies or end of service forms, etc. So please, if you have a nominee form, please complete that form. It is the safest option to ensure that money is paid out. And for a second practical reason as well, that money will likely reach the nominated person long before anything reaches them under a will. A will still take time to be carried out after a person's passing, whereas an employer will likely pay those funds over, and they could be very necessary funds to help float your family or children, etc., in a time of need after your passing. So please, by all means, complete those nominee forms. It's very important.
In fact, I would like to step in here. Many of the end of service benefits, if they are linked to a group insurance and things like that, then they would still need an order from the court before that can be settled. Just a nominee on that may not be sufficient.
Yes, yes. It will all depend, and on a case-by-case basis it can. The only thing is that even then, under those circumstances, it would follow the same route. So it would never fall into a person's estate. It would transfer directly then under that court order. But I'm going to speak of a probate grant, all right, a grant of probate, because that's the order that will be granted in respect of a probate will, and it will then give the executor or executrix the instruction to take it to the employer, show this to them, and they will then have the authority to have it transferred directly. So again, it will not come into the deceased person's estate.
Right. I think, Reza, we have another 5 more minutes. Luna, we can take a few more questions.
Please,
Great.
by all means.
Please.
Great. Okay, and someone says all bank accounts and insurances do come with a nomination facility. So in case of no will the nominated person will still be honored of their dues? I know about insurance, but about banks, I'm not clear. Maybe someone can step in.
So yes, the banks will do so. However, there is so the banks will automatically freeze any accounts that are held. Right, that will happen by automatic operation of the law. As soon as the bank finds out that a person is deceased by whatever governmental registry, they will receive that information. They will automatically freeze the account. Then please remember, so even if you don't have a will, you still have an estate. Now you just determine whether your estate will devolve by intestate succession, meaning you have no will, or it should devolve by testate succession, where under you do have a will. So it will still follow the same process. Under where you don't have any will, they will follow Sharia law application, and where you do have a will, they will follow the exclusion of Sharia law therein under. So it will still follow the processes, but the application would just be different.
Another technical question. Can I have alternative executors? If I have more than one executor as an alternative, will this be allowed?
Yes, absolutely. So as opposed to the word alternative, what I could say is that you could have joint executors, meaning that you could have 2 or more persons that will be jointly appointed to execute and administer your estate, and each one will have authority to take permission also from the other joint executor to make a decision accordingly. So one cannot act without the other. Then in the alternative, if you only want one and they cannot or will not act, or they pass away before you, then you substitute them with a second nominee. So I hope that sufficiently answers the question. But yes, you can have more than one person. It just depends. Do you want them to administer the estate together alongside each other, or do you want them to administer it if the other one cannot?
Here is another question, probably I can also take it. It says, for insurance policies with nomination done already, do you still require a will? For insurance policies, there is a provision if there is a rival claim. For example, there is a claimant, a beneficiary who is nominated, but example, wife. But if the parents of the deceased come and say, we do need part of it, then the will is necessary, or until the court decision comes, this cannot be paid.
Mr. Raju, thank you. I couldn't have said it better myself. So please remember that, yes, my initial answer would be to, maybe not necessarily. However, again, it's risk mitigation. There is a chance always that a will or that a person's estate can be contested by persons who do believe that they have entitlements in terms of that estate. So what can happen there and under is that if you are the named beneficiary, your right in terms of the benefits under an insurance policy can be challenged by any person that has a claim of subsistence or some financial assistance from a deceased person's estate. And what can then happen is that a court can intervene and actually recognize that third party as needing funds. And the only source of funds where they can draw it from is then maybe from that insurance policy. So they could then cut that insurance policy in half and say, half should go to that person and half not. If there is a will in place and that will says that the inheritance should go to the specific named beneficiary, then that is what will stand and what the court will apply. because that was your last testamentary wish and your directive to the court.
Yes, yes. Right. And what are the chances that contents in a registered will not be accepted by judge in a court at the time of hearing?
So that's difficult to say, because it will depend on a case-by-case basis. A will can seem very straightforward, you know, from just having a look at that. So on face value, it can look very straightforward. But once a person passes away, you know, I'm always reminded of the saying that money is the root of all evil. Unfortunately, we see a lot of people coming to the fore and coming out of the woodworks with all kinds of claims and relevant debtors, or, you know, creditors of whatever kind, whatever the case may be. Everybody then comes and lays their stake in respect of that person's estate. So it's an unfortunate part thereof, and a reality that is to be faced. So again, to safeguard yourself, have a valid will in place to guide exactly what is to happen.
Great. Okay. Thank you. So I'm going to combine three things into one. Does Karam, do you provide executor services? And is there an advantage of having an attorney as an executor? And how long does it take to execute the will?
Okay, thank you, Mr. Raji. Yes, Karam does provide executive services. We're happy to do that because we do work with estate planning and the administration of estates. So that is the professional function that we perform. There are advantages to having an attorney, only insofar as, and please, I'm not advocating ourselves now, but just insofar as the understanding of the processes, our familiarity with the judicial bodies as well as the other authorities. So as one example would be, if there is a transfer of property in, let's say, the Emirate of Dubai, we're familiar with the Dubai Land Department, we understand the processes, procedures, costs, etc. We can account for an estate, we can do financial reporting on an estate, we have access to auditory services, we know about the tax laws, etc. So we are enabled and knowledgeable and skilled in order to handle these types of things. So if that is something that you'd like to take away as a burden, or that could be cumbersome to another third party, then yes, there is a benefit to having an attorney to administer your estate. Mr. Raji, sorry, what was the final question?
How long will it take? How long?
Thank you. That's a great question. All right. So I cannot say with certainty, because this does change from week to week and month to month. We are reliant on federal bodies here in the UAE, and also now with the COVID-19 situation. Although this is a situation we're faced with now, we may not be faced with it in 5 years, but in 5 years' time, we could be faced with several other things, etc. So again, it's about the unknowns and uncertainties of the world. However, generally speaking, at the present moment, if somebody does report your estate as a deceased estate, they report to the offices of Abu Dhabi Judicial Department. The executor must ideally approach the department themselves, and they must provide proof of their identity, and there's a couple of forms that they need to complete, and then thereafter it follows the process for the granting of a probate, a grant of probate, which is essentially a court order that takes between 6 to 8 weeks from a person's passing. So if all runs smooth and there's no issues of interference, etc., then that is what happens. Why I qualify this statement is that I've been involved in matters previously where there was contention as to the cause of death of a deceased person, where a wife was accused of, as silly as this may sound, she was accused of not helping her husband as he was choking on food, and therefore was considered to be a suspicious person by the police. And what had then happened was that this person could not be laid to rest, and there could not be a death certificate with a cause of death issued for a period of approximately 3 months. So that delayed the process significantly. So for what, if all goes well and there are no such unnecessary interferences, then it should take 6 to 8 weeks for the issuing of the court order.
Thank you. Thank you, Luna. I know there are still a lot of questions. And yeah. Okay, I'm sorry for this, but some of them I would like to combine and probably ask that. There are many questions about what happens after the will is executed and the assets are obtained later on. Does it need to be added subsequently? Will there be legal issues? And do you have to keep updating it frequently? That is a combination of 2-3 questions.
That's a great question. Thank you. So if you have worded your will broadly, in the sense that you say all immovable property, this is what is to happen with such property, then any property, immovable property that you have registered in your name at the time of your passing will be subject to the provisions of your will. If you have specified property and you acquire new property and you wish to have that property bequested to a specific person, then yes, you have to change your will or revoke and replace your will, whichever applies in respect of the specific regime, and I'll come back to that now. It depends on your wishes. So you should always be mindful of what your will says and how you'd like to plan for the future. Manav can attest to this. Manav and I had drawn up a will for a couple, also under the Nexus Wills package, who did not have any children at the time of execution of their will, but they knew they would have children, or they knew that they would have more children. So you keep it very broad, and you then don't specify only your children. You can keep it broad and say any children that are alive at the time of my passing should benefit in my estate equally, meaning then it is divided equally amongst the number of children that you do have at that time. Same with property then, any and all immovable property, any and all bank accounts, etc. However, if you have specified something, or you wish to change something in your will, if you wish to remove some or other person from your will and not having them benefit in your will, then yes, absolutely, you have to change your will. If you effect an amendment to your will under the Abu Dhabi Judicial Department Service, they need you to go through the registration process again. So it's essentially going to be a revocation of your earlier will and replacement with the subsequent will and having that executed. Under DIFC and RAC ICC, they work a little bit differently. They allow for amendments of the will at a nominal cost. So they charge 550 dirhams plus VAT per change. Abu Dhabi Judicial Department charges 950 dirhams for the execution of any will. So for any will done subsequently, it's going to be 950 dirhams for any changes, or then any new will you then do. So I think it's good housekeeping, and it's a personal responsibility exercise that one has to carry out. Be mindful of what your will says and update it accordingly as per your wishes every so often and as your personal status changes.
Thank you, Luna. Last 2 questions. But before that, there have been a number of questions asking about the specific cost of actually doing it. What I would request is please speak to the consultant. It depends on your individual need, whether it's ADJD or DIFC. And again, if it is a mirror will or it is a single will, all these things. Reza, would you like to take it up?
Yeah, Raju, seeing that there have been a lot of questions, I can try to give a basic answer. Basically, to draft a will in English language, the cost for a single will be 2,750 dirhams plus VAT. For a mirror will, the cost would be 3,350 dirhams plus VAT. In order for the will to be valid in the UAE, it has to be translated into Arabic. For a single will, it would be 600 dirhams. For a mirror will, which is essentially 2 wills, it would be 1,200 dirhams. The government fees for registering a will at ADJD are 950 dirhams. And so for 1 will is 950, for 2 wills would be 1,900, that's for a mirror will. Now, if you'll be provided with basic information on how to register the will at ADJD. However, if you want additional support from CALM, they've actually agreed to support the client for making an appointment and also attending the call for a nominal fee of 150 dirhams. If you wish to arrange for it to be notarized for your own reasons, then they would be happy to support you in the notarization process at, again, a nominal cost of 150 dirhams per will. However, bear in mind that notarization would attract additional costs. If you wish to register or lodge the will at your own respective consulate, again, based on your requirements and your needs and the jurisdiction which you come from, then again, CALM have kindly agreed to support the clients at a nominal cost of 150 dirhams per will. And as Luna has mentioned, if you require a consultation before, during, or after proceeding with a will, the cost would be 850, which is over 50% lower than the usual hourly charge for CALM. Now, please add the VAT to all of these numbers which I've said, and of course for DIFC and for RAC there are additional costs. There are different costs.
Correct. Also, just to add to that, Reza, if I maybe can give everybody, just to put it into perspective as to why this wills package has been structured accordingly, is because we're trying to be facilitators in this regard. The cost of notarization alone of a will under the, I can quote now for the Dubai courts, only for notarization is at the moment 2,500 dirhams excluding VAT. So that's not even for the drawing of your will, etc. So in the package deal, we've tried to make this accessible to everybody. It's something that is necessary, and again, it's just, it's a personal responsibility exercise, and we want to make it accessible, and as such act as facilitators herein.
Thank you, Luna. Now, Mr. Raju, I know that there are many other questions, but do you want to just share the last question with Luna as we are running over time?
No, I know. Reza, what I would like to advise all the attendees once again is the consultants at Nexus have been trained and have been authorized to take you through the process. And I'm sure if you speak to your consultant, they'll be able to brief you on every aspect of whatever we have discussed right now. And if there is a very special case, we can always get back to Karam and they will be able to come back to us with clarifications. So please do get in touch with your consultants. They are perfectly in position to answer many of the common questions that we have faced today. In fact, there have been many complicated questions as well, which I'm glad nobody raised it today, but we could have answered them as well. There is, a spouse, one of the spouse being a Muslim and the other one being Hindu. There are a lot of other questions as well. So please do contact your consultant. They'll be able to raise it with us, and then we will still be able to come back to you. Once again, I would like to thank all the attendees for taking the time out today and being with us at the webinar, and specifically to Luna and Manav. They are lawyers and their time is very, very valuable. Thank you very much. Thank you very much for being with us and very patiently answering all the questions that we have raised. It was almost more than 40 questions. Once again, thank you very much. We're truly indebted to you. And we would be making this available. If in case anybody wants it later, please contact your consultants and we'll be more than happy to share some of this information with you. All right.
Raju, thank you so very much. Reza, thank you for hosting us today. And you mentioned our valuable time. We acknowledge that it's everybody's valuable time. This is time taken from being able to do other things for addressing something very important to everybody. So thank you so very much. Thank you for the opportunity, and lovely speaking with you all today.
Thank you. Thank you very much. Thank you.
Thank you.
You take care, everybody. Stay safe, and I hope to hear from you soon.
Take care.
Take care. Bye-bye.
Thank you.